Well, good afternoon, everyone, and welcome to July's Employee Benefits Compliance webinar. As we get started, you're going to see two polling questions pop up. What we would ask is if you wouldn't mind taking just a brief moment to respond to both of these. We're curious about your perspective on employee benefits, specifically how you're seeing your strategy evolve over the next several years and what trends you're monitoring most closely. So if you would mind, again, please take a moment to submit your responses. As you're doing that, I want to again welcome you to today's webinar. I'm Dan Gowan with AssurexGlobal. Today, the team from Loomlight will cover HIPAA privacy and security rules. And just as a reminder, in case you've missed our last couple, benefitcomply now has a new name, and it is Loomlight. Benefitcomply is now a part of Loomlight, so you're going to hear that name moving forward. The same team that you've come to know and love will still be leading all of our webinars, and we'll meet some new experts along the way as well. As we're getting started, we'd also like to extend a special thanks to the local insurance benefit advisors and consultants who are partners of AssurexGlobal for making today's webinar possible. We welcome your questions today. If you have them during the presentation, please submit them using the Q&A function at the bottom of your screen. We'll address as many of those as we can throughout our time today. Again, if you've just joined us, you'll see a couple of polling questions on your screen. Please take a moment, provide your responses. I'd also remind our audience today's session is being recorded, and a link to that recording as well as a copy of the slides will be available early next week from the benefit advisor who invited you here today. I'm also going to drop a link to the presentation slides in our chat section in just a second. I'm going to leave the poll up for just a couple moments, and again, thanks as always for responding to them. We publish all of these results from the polls in various formats, including our monthly market check surveys. It's a great way to get what we think is a timely pulse on how other employers are thinking about various employee benefit and HR issues. So if you'd like more information on that, please, again, reach out to your benefit advisor. All right, we're going to get into today's content. I'm going to end the poll here. But while I do that, joining us from Loomlight today are three presenters, Delaney George, Dan Brady, and Brianna Barnett. And team, with that, I'm going to turn it over to you. Delaney, please take it away.
Thank you, Dan. Right. Let's jump in with some HIPAA privacy and security. Also on the call with me are Dan Brady and Brianna Barnett. They're going to be helping out as well. All right, and we'll start off with another thank you to AssurexGlobal partners. And we'll start off with some background around HIPAA legislation. Then we'll get into the real meat and potatoes with the privacy and security rules, and then wrap up with breaches, which can be what really brings attention to HIPAA compliance for employers. So with that, so evolution of HIPAA. HIPAA is the Health Insurance Portability and Accountability Act. It was enacted in 1996. So been around for 30 years now. It was a fairly broad law because what was happening in the 90s was all of these medical records were starting to be digitized, and legislators saw a need to regulate that, to standardize that, and to protect all of that personal data that was being part of this. So HIPAA came to be. In the early 2000s, then, we have several regulations issued that implemented the privacy and security requirements under HIPAA. And when we think about HIPAA, these are the rules that we tend to think about that really set the standards for how protected health information, or PHI, can be or must be treated. In 2009, we have the Health Information Technology for Clinical and Economic Health Act, or HITECH, which had the first substantive changes to that 1996 law. It increased potential penalties for noncompliance, required greater oversight and enforcement of HIPAA by the agencies. It also changed how to identify a breach and what would need to happen if a breach occurred. And then lastly, there was an expansion to make business associates directly liable for HIPAA compliance. Um, and then we have the omnibus final rule in 2013 that finalized all those rules and actually incorporated all of high-text changes into HIPAA. And then we had a nice long dormant period until just last year. We had the introduction of the 2024 privacy rule, which we'll get more into in the privacy rule section. But for now, it had created stronger protections for certain types of PHI, but was also very recently largely vacated by district court judge. So important to note, but also somewhat of a moot point at this point. Um, then at the beginning of 2025 this year, we had some proposed changes to the security rule. I want to, I italicized it, but I should have bolded it, underlined that they are proposed. There is nothing different right now around the security rule, but these are important things to be aware of and really helped kind of inform how the agencies view the security rule, even in its current form. Okay, so who do all of these HIPAA rules apply to? HIPAA applies to what it calls covered entities and business associates. Covered entities being who we generally think about when we think about HIPAA, your healthcare providers, doctors, hospitals, etc. Clearinghouses, those technology firms that process claims, so lots of personal data there. And then also kind of roped into that covered entity designation were employer-sponsored health plans, because like those other folks, though they're not providing medical care, they house a lot of that PHI or protected health information, which we'll define in just a minute. And then there are business associates. Business associates are third parties that perform certain functions, jobs on behalf of covered entities, and as part of that necessarily then use or disclose PHI. And what's important is that these business associates have the covered entity's permission to use that PHI and that the covered entities have reasonable assurances from the business associate that they are going to protect all of that PHI as required under HIPAA. And we see those reasonable assurances take the form of a business associate agreement that has to be in place in order for a business associate to compliantly have access to, use, disclose that PHI. Brokers, our business associate, if you receive, look at, use PHI, you'll be in a business associate that needs a BAA. There are also less obvious examples of business associates. For example, an employer hires an outside IT consultant. Though that IT consultant may not be using PHI at all, they may necessarily then have access to wherever that PHI is stored as part of their job. And so that is technically a business associate and they need to have a BAA in place for compliance sake. I said we'd define PHI. What is the information that HIPAA protects? And protected health information is any individually identifiable health information that is created, received, or maintained, touched, if you will, by the health plan, by the covered entity in this case. And it's important to realize that that what is considered health information is it's broader than what you would typically think of. It goes beyond just like treatment, diagnosis, like medical information. It includes things like a name, date of birth. Those things would be considered health information, and being individually identifiable if they are touched by the covered entity, the health plan, then it will be considered protected health information and protected by HIPAA. As opposed to things that are not considered PHI is health information that is collected by the employer in their role as the employer versus in their role as a plan sponsor. So good examples of that are like drug test results that, looks, feels, smells like health information because it is, but it has not been touched by that covered entity, the health plan, so it is not PHI. Same goes for, any health information for workers' comp claims or FMLA claims, payroll information that the employer maintains. And what this is all really getting at is that part of the trick in defining PHI is realizing that you may have identical sets of data. You may have two pieces of paper that each says, Dan Gowan on it, but only one came from that health plan. And so that is the only one that will be considered PHI and protected by HIPAA. That isn't to say that there aren't other HR laws that would protect this other information that is still sensitive and needs to be treated appropriately, but it won't be protected by HIPAA. So looking more closely at health plans as covered entities, and I've hinted at this distinction already a bit, and it can feel like splitting hairs a bit, but it's important to realize that it is the health plan, not the employer, that is the covered entity. But health plans, being non-sentient, cannot comply with HIPAA on their own. So plan sponsors then are responsible for their health plan's HIPAA compliance. And so when you're thinking about, health information, whether HIPAA is involved, you kind of have to ask, okay, is the employer wearing their employer hat or their plan sponsor hat when, they're dealing with sensitive information? And that can help determine whether it's PHI. Not all plans that an employer offers will be subject to HIPAA either, though. The HIPAA privacy and security rules apply to employee welfare benefit plans that provide medical care. On the screen is a table that categorizes some common benefits into their typical categories in terms of whether or not they are subject to HIPAA. But as you can see, though, with the number of asterisks there, it's not always a clean cut or black and white. Some of these benefits, you have to look a little bit deeper to see what's being offered, how it's structured maybe, in order to determine whether they are offering healthcare and subject to HIPAA. For example, an EAP, Employee Assistance Program, often they provide some sort of counseling session. And as a mental health offering, that is considered medical care. And so most EAPs will be subject to HIPAA, as opposed to an EAP that may offer just like financial advice or just referrals to a counselor even. The EAP is not providing medical care, and so will not then be subject to HIPAA. Okay. Additionally, a health plan's and thus a plan sponsor's HIPAA obligations can depend on how a plan is funded and also what level of access the plan or really the plan sponsor has to PHI. First, self-funded plans will always be subject to the privacy and security rules, regardless really of what level of access they have. That also goes to level funded plans, which are, for compliance purposes, considered self-funded. So they're going to fall into that bucket as well. Fully insured plans then there's two kind of approaches fully insured plans can take. One is that hands off and hands on. Hands off, these fully insured plans only have access to PHI that can be considered summary health information or enrollment information, the definitions of which are on the screen. Um, and if that is the case, then that health plan will be exempt from the HIPAA privacy rule, but for a couple of administrative requirements, the prohibitions on retaliation for exercising HIPAA rights, or on a waiver of HIPAA rights. Uh, However, even for these hands-off fully insured plans, there is no clear exemption for them under the security rule, so they will still need to comply with the security rule. Hands-on fully insured plans will be those that do have access to PHI that goes beyond summary health or enrollment information. And then they will be in the same bucket that self-funded plans are. They are fully subject to both the privacy rule and the security rule. Okay. Right.
And
Next up.
one quick question before you move on, Delaney, about
Oh,
self-funded
great.
plans.
Thank
Yeah,
you.
so it was my understanding that there's also an exception for self-funded plans with fewer than 50 participants. Can you clarify that a little bit?
Yes, yes, and there that does exist, but there is a reason I didn't put it on the slide, and that is that that exception only applies when it is a self-funded plan, but also a self-administered plan. So, like the health plan has to be fully in-house for an employer for that exemption to apply, um, which just doesn't happen a lot, but it does exist. So if you do have an employer that fully administers and funds their own health plan, then if they have fewer than 50 participants, they will be exempt from the HIPAA privacy and security rules. All right.
Okay, privacy rule. Well, we do have a couple questions here. Maybe I can
Oh
jump
yeah.
in
Oh,
and answer
yep.
those quickly. So the first one is, what if you have an employee that reports to HR that they have a substance use disorder and are seeking help? How does HIPAA protect that employee? Um, I think one important distinction here is that really in that scenario, the group health plan isn't there's no protected health information going to or from the group health plan in that situation. So that's not to say that there aren't other general employment privacy requirements that the employer can go and share that information with others. But you're not really dealing with PHI there when an employee comes and is talking to the employer specifically. Um, and the same would, and I'll talk about this a little bit more in a bit, but I mean the same kind of goes for a leave of absence. Um, and in addition to that, typically when the employee is forthcoming and offering the information to the employer, let's say that is essentially like an authorization, and so again, because it's not being handled by the group health plan, the employer can take care of that situation as necessary. Um, so with that, can dive into the privacy rule. So put simply, the privacy rule implements a set of safeguards regarding the use and disclosure of PHI. And there are really three core requirements. But as Delaney mentioned, the extent to which the privacy and security rules are applicable really depends on whether the plan is fully insured, self-insured, and the plan sponsor's access to PHI. But under the privacy rule, the three core requirements include use and disclosure rules. So, as the name suggests, these dictate how and when the covered entity, the health plan, can handle PHI. Uh, The second requirement deals with an individual's right to access their own PHI and also imposes notice requirements on the employer. And then the third core requirement, and I'll talk more in depth about all of these, but the third requirement deals with the administrative safeguards, which includes designating a privacy official, employee training, and implementation of policies and procedures. So looking at that first core requirement, permissible uses and disclosures of PHI. So HIPAA provides that covered entities are prohibited from using or disclosing PHI except as required or permitted by the privacy rule. And these requirements extend to both the employer plan sponsor and business associates who contract with the health plan if these entities have access to PHI. In general, HIPAA allows covered entities to use and disclose PHI in the following circumstances without receiving authorization from the individual to whose PHI we're talking about. And that includes certain covered functions such as treatment, payment, and healthcare operations with respect to providing specific information to certain family members and personal representatives, and then for public policy purposes. So looking at that first category there, treatment, payment, healthcare operations. Treatment really has to deal with sharing PHI to coordinate and manage healthcare, typically between healthcare providers. So there's really kind of limited practical impact on health plans under that category. Payment generally includes activities like eligibility determinations, premium billing, claims processing, coordination of benefits. And then healthcare operations refers to activities compatible with and directly related to both treatment and payment. So like quality assessment, case management, etc. Most often when dealing with the use and disclosure of PHI, we are concerned with the group health plan disclosing that information to the employer. And HIPAA permits plans to disclose PHI to the employer for plan administration functions, which fall within that payment and healthcare operations categories. In order to do that, the plan has to have what is referred to as a firewall in place, which essentially describes employees who have access to PHI and then actually restricting that access to those individuals and then having procedures for resolving issues of non-compliance in place. Plan administration functions refer to tasks that are performed by the employer plan sponsor on behalf of the group health plan that require access to PHI but are not for employment purposes. Moving on to disclosures to certain individuals. HIPAA permits the health plan, to disclose to certain individuals the PHI of another individual if the PHI is relevant to that person's involvement with the individual's care or payment. Specifically, the covered entity must treat an individual's personal representative as the individual with respect to the PHI. So, for example, a personal representative may sign an authorization that allows the plan to disclose PHI or would exercise an individual's right to access PHI. Parents of an unemancipated minor would be an example of a personal representative. So this may be obvious, but a parent can access the PHI of their minor child without getting authorization from the minor child. Spouses, on the other hand, will most often not be an individual's personal representative for purposes of the HIPAA privacy rule, simply by virtue of them being married. In other words, one spouse does not automatically have a legal right to make healthcare decisions on behalf of their spouse. And the same would apply to adult children. The guidance does state that it is acceptable for the plan to communicate with a spouse, for example, regarding bill payment, as long as the disclosure complies with the minimum necessary standard that I'll talk about in a little bit. And then finally, public policy. Plans can disclose PHI without authorization for what I believe are 12 specific public policy reasons, and those include judicial administrative proceedings, law enforcement, medical examiners, serious threats and to the health and safety of an individual. Um, and then that brings us to the 2024 privacy rule, which we've had some recent updates on. Um, so I'll kind of gloss through this pretty quickly, but essentially, and Delaney mentioned this, so in 2024, HHS issued the HIPAA privacy rule to support reproductive health care privacy that amended the existing privacy rule at that time to provide greater protection to PHI related to reproductive health care. That rule incorporated, or it added and clarified some definitions, imposed an attestation requirement that the health plan would use whenever they're receiving a request for PHI related to reproductive health care. And then also included a requirement to update the notice of privacy practices, and that deadline was set to take effect February 2026. However, in June of this year, a U.S. District Court in Texas vacated the vast majority of this 2024 privacy rule, which essentially means that we're reverting back to the rules that were in place prior to 2024. So, for employer plan sponsors who may have been a little bit slow to get into compliance with these requirements, they are in luck because we are going back to the rules that were in place before these took effect. If employers did amend their HIPAA policies and procedures and training materials and notice of privacy practices, they'll need to go back in and review that material and then likely amend it so that it is in compliance with the requirements that were in place prior to 2024. And we are expecting a model notice of the privacy practices to be issued prior to the new 2026 deadline. Getting back into the permissible uses and disclosures. So in certain situations, a covered entity may use or disclose PHI as long as an individual has had the opportunity to agree or prohibit or restrict the use of or disclosure of that information before the actual disclosure of the information. So one of these situations is a disclosure to family members or close personal friends. The key is whether the individual whose PHI we're talking about has the opportunity to agree or object to the disclosure of that information, which then can depend on whether that individual whose PHI is being disclosed is present when the disclosure is taking place. So if the individual is present, then the plan can disclose PHI if that individual agrees that their information be disclosed, or if the employer can reasonably infer that the individual doesn't object. It's not really related to health plan, but one kind of example of this would be if you and your spouse go into a doctor's office and go into the room where the doctor is giving information, they can basically infer that by having your spouse there that you consent to the spouse hearing your PHI. If the individual is not present, then the covered entity must exercise professional judgment. The regulations include an example of a permissible disclosure as a beneficiary's daughter who has called to assist with her hospitalized elderly mother in resolving a claim payment issue. That would be an appropriate situation where they could disclose PHI to the extent necessary to handle that claims issue. In any situation where the disclosure of the PHI is not specifically permitted, then the covered entity must obtain the individual's authorization in order to disclose that information. So we do not have a model notice of what that authorization would be, but the final regulations do incorporate several core requirements, such that it has to be written in plain language. It cannot be combined with other documents. It can be an electronic authorization with an electronic signature. The individual can revoke their authorization at any time, and the specific authorization form needs to include the purpose of, why the covered entity is going to use or disclose the information, an expiration date, a description of the information being used, identification of the persons that are authorized to access the information, and then a signature and date as well.
Hey, Dan, I just want to address a couple of the questions before we move
Yeah.
on, just so everyone's on the same page. And we have a couple questions around, you know, what is considered PHI? Like if in an email, there's like an employee's diagnosis or treatment, is that PHI? Why isn't workers' compensation PHI? Um, and what it really does come down to is where is that information coming from? So is that email with that information coming from the employee themselves? Then that is not PHI because a covered entity has not touched it. For workers' compensation, again, if that information is coming straight from the employee, not PHI, versus though if the information's coming from the employee's doctor, another covered entity, that can be PHI, and the employee must then authorize that disclosure. And then a clarification around what kind of consent is needed for sharing PHI of a spouse or an adult child. And yet, like Dan said, there are written authorizations you can do, or there's that opportunity to agree or object where, maybe an employee calls in and has a question about one of their spouse's claims. Before you can talk to the employee about their spouse's claim, the employee can hand the phone to their spouse, and the spouse can okay that disclosure, and then you're okay to talk to the employee about their spouse's claim. I guess one thing about the opportunity to agree or object, though, that verbal authorization will only be good for that specific interaction. So if the employee calls again an hour later to clarify something, you'll have to get the spouse's permission again. So, okay, thanks, Dan. I'll change the slide now.
Yeah, so I mentioned kind of the minimum necessary standard. So anytime we're talking about actually disclosing that PHI, the general rule is that the plan must make reasonable efforts to ensure that when it is disclosing that information, that only the minimum necessary information needed to accomplish the intended purpose is used. So there are some kind of common pitfalls that we see. Um, One example is going to be an email chain. So if let's say the plan has a list of people who can access PHI, one thing they want to make sure they're certain of is if they are exchanging the PHI, that there isn't some unauthorized individual who, may be included on an email chain. For recurring disclosures and requests for PHI, the covered entity needs to implement policies and procedures that limit the PHI that it discloses only to the minimum necessary needed for the intended purpose. I want to mention business associates. So like covered entities, business associates must make reasonable efforts to limit their use and disclosure of PHI. The BA agreement should limit the BA's uses and disclosures, and it should be consistent with the covered entity's minimum necessary policies and procedures. The BAs can be directly liable for violating this minimum necessary standard. So it's really important that everyone's kind of on the same page in terms of what information can be used and disclosed. There are some exceptions to the minimum necessary standard, and that includes disclosures to or requests by a healthcare provider for treatment information, uses and disclosures made to individuals as specifically required under HIPAA or as permitted by law, and uses and disclosures made pursuant to an individual's authorization. There are some specific impermissible uses and disclosures as well, and this would include employment-related actions or decisions. So hiring, firing, promoting. For example, an employer cannot terminate an employee because they learn of the employee's high claims cost, or they learn that an employee is seeking counseling for a mental health issue. Um, Disclosures to employees that are not involved in plan administration would be an impermissible disclosure. Again, plan administration functions are going to include activities within the payment and healthcare operations that I mentioned. We talked about disclosing to adults who are not considered the personal representative of the individual. In that case, again, like we just mentioned, you're going to need authorization. And then also in connection with other benefits or employee plans, so FMLA, disability, etc. One example, an employer might require that an employee submit a medical certification for FMLA. If that information is coming from the provider to the employer, then technically the employee would have to authorize that the provider can provide that information directly to the employer. The notice of privacy practices. So covered entities generally have to provide a notice of privacy practices to each individual who is the subject of PHI. And the notice must describe the uses and disclosures of PHI that may be made by the health plan, the individual's rights with respect to their own PHI, and then the covered entity's legal duties with respect to the PHI as well. The notice has to be provided to new participants, typically included in enrollment materials. It can be provided electronically if the individual has agreed to electronic notice. It has to be provided to anyone, whether they're a participant or non-participant who requests it. And then it has to be provided within 60 days of any material revisions that are made to the notice. And a reminder that the notice has to be sent, a reminder of the notice has to be sent to participants every 3 years. A lot of employers will simply just include this in their annual communications that are provided to employees. So moving on to that second core requirement I talked about, HIPAA privacy rules require covered entities and business associates to provide individuals with certain rights to access their PHI, amend their PHI, request an accounting of disclosures of PHI, request confidential communications of PHI, request restrictions on the use and disclosures of their PHI. Individuals need to be able to make complaints, and then individuals also have a right to receive the notice I just talked about. And anytime a covered entity, so the health plan, gets a request, they are required to respond. The third and final core requirement is going to be the administrative requirements. And these essentially require covered entities to reasonably safeguard PHI from intentional or unintentional uses or disclosures. These are kind of often referred to as the mini security rule. And Delaney will talk more about the security rule, but the administrative requirements are essentially broken down into 3 categories. Physical safeguards, as the name suggests, this is dealing with the physical security of PHI. So, we're locking doors or offices that house PHI, file cabinets containing PHI, shredding documents that contain PHI prior to disposal, restricting access to work areas. Technical safeguards, these are going to be technology related. Examples would include role-based access controls, password protections, etc. Most of these requirements are found within the security rules. And then finally, administrative safeguards, which includes administrative actions, policies, and procedures necessary to protect the PHI and manage conduct of the covered entity's workforce in relation to that protection. And Some examples could include identity verification, not discussing PHI out loud, etc. Kind of sticking with the administrative requirements, there are a few specific that you may be familiar with, and starting with the appointment of a privacy official and contact person. So the privacy official is going to be a person responsible for developing and implementing the covered entity's privacy policies and procedures. This specific role is going to depend a little bit on the size of the employer. Small employers, this could be an office manager. Large employers may have a specific compliance person that's handling this. The contact person must also is there to receive complaints and provide additional information about matters that are covered in the privacy notice. This is going to be more of a limited role than the privacy official. The covered entities are also required to provide training. This is going to typically include any employee who may have access to PHI. There is no specific training design or program design. It really needs to be tailored to the specific employer and job based on an individual's potential access and responsibilities regarding PHI. These next two are probably pretty obvious. A health plan is prohibited from intimidating or discriminating against or threatening or taking retaliatory action against an individual for exercising their rights under HIPAA. Waiver of rights. So covered entities cannot require an individual to waive their right to file a complaint with HHS or waive their rights under the HIPAA privacy rule in order to be eligible for benefits or enroll in a group health plan. Written policies and procedures. So covered entities have to implement policies and procedures with respect to the PHI. These should be reasonably designed to ensure compliance with the privacy rule while taking into account the covered entity, the types of activities they are involved in regarding PHI, etc. And this is separate from the notice of privacy practices I talked about. A lot of the information is similar, but the policies and procedures is more broad. Business associate agreement. So the covered entity must enter into a written agreement with the business associate in order to disclose PHI to the BA or allow the BA to create or receive PHI on the entity's behalf.
Regarding your first bullet point, Dan, do you mind expanding on that just a little bit in terms of who can actually be a privacy official? Can it be a third party? Does that have to be someone directly related to plan management? Can you talk about that a little bit?
Yeah, absolutely. So there is no requirement that the privacy official be an employee of the covered entity. As a practical matter, a group health plan itself is not going to have any employees. So in virtually all cases, the privacy official is going to be an employee of the employer plan sponsor who is sponsoring the group health plan. There isn't anything, like I said, that specifically would prohibit like a TPA or someone other third party from being privacy official. That would be pretty rare. The privacy official has to have a good understanding of the workforce as a practical matter and kind of how they're handling PHI. So like I said, it's typically going to be an employee of the plan sponsor. And then also the covered entity, the health plan, is legally responsible for HIPAA compliance and the one subject to penalties. So typically, plans and employers will want to keep that in-house.
Thank you, Dan. Just a quick question. Does a self-funded employer need a privacy official?
Yes, they would. They're going to have. They're going to be hands-on. They're going to be handling PHI, so they would be required to designate a privacy official.
Thanks, Dan. We'll dive into security. And I do see we do have a question around email, PHI in an email. And that's a great example that I'll be able to answer through this section. So the security rule applies to electronic PHI, ePHI, which you may have guessed is PHI that is in an electronic medium, which these days really is most PHI, is ePHI. And the overarching goal of the security rule is to ensure that covered entities are putting in place appropriate security measures to safeguard the ePHI that they're holding. To that end, the security rule contains 4 safeguards/requirements. You may recall the mini security rule that Dan described in the privacy rule. These safeguards will apply to the ePHI as well as organizational policy, procedures, and documentation requirements. Then within these safeguards, there are 22 standards. Each have anywhere from 0 to 4 implementation specifications. And to bring it back to the email question, under technical safeguards, there is a standard for transmission security. And one of the transmission security standards implementation specifications is encryption. The question of whether ePHI must be encrypted when transmitted. And here's where the security rule was written to be flexible in its implementation, because as you can see on the screen, every implementation specification is designated as either required or addressable. Required ones are just that, they are required. Whereas addressable ones, covered entities are permitted to kind of take into account their own size, goal, types of PHI that they have, to determine what is going to be most appropriate for safeguarding the ePHI that they have. So, for example, much more stringent security protocols are going to be more appropriate for a hospital, which has gobs and gobs of ePHI and often can be life or death stakes. So the very high stakes versus a group health plan, which there's a lot of ePHI still, but may not be quite as high stakes. So when you're looking at these implementation specifications, the security rule was written to give some leeway in terms of how that specification should be addressed. However, there are the proposed changes that we talked about, and we'll get back around to it. But just put a pin in that for now, before we get to the proposed changes, and I'll pick that back up again. But for now, health plans there are certain things that health plans have to do to comply with the security rule. And the very first integral step is always going to be conducting a risk analysis, a thorough and accurate assessment of any potential risks and vulnerabilities to the confidentiality, integrity, and availability of the ePHI that covered entity holds. This risk analysis is really the bedrock for any covered entity's compliance with the HIPAA security rule, because they're going to start out mapping out all of the ePHI that you have. Where is it? How is it held? Who has access to it? What kind of vulnerabilities are there to it? What is the type? You'll look at all these things. What kind of security measures are around it currently? What are the risks then due to the current security measures? And that is the risk analysis, which will then inform the security controls that you then put into writing in your written security policies and procedures. Which themselves, those written policies and procedures are a requirement then, which is difficult to do without the that first step of the risk analysis. Like the privacy rule, there's also a requirement to appoint a security official who will be ultimately responsible for the implementation and enforcement of those security controls that through the risk analysis are determined to be reasonable. There's also a requirement to conduct security awareness training, and where Dan kind of touched on the HIPAA training that would be necessary for anybody with access to PHI. This security awareness training requirement more so speaks to identifying phishing scams or other fraudulent behavior. It's more generic than just HIPAA. Periodically testing, evaluating, refining these security controls. I can see we do have a question asking, how often do you conduct a risk analysis? Well, there is a requirement that the risk analysis is periodically reviewed. There currently is no hard line time period for that under HIPAA. It is one of those things that it's flexible on, that's like however often you think it needs to happen. But whenever your work environment, your workforce changes, the likelihood, it's very likely that the information in that risk analysis is going to change. And so it will need to be updated in those cases, because if that risk analysis is out of date, then your written security policies and procedures are also going to be out of date, and just speaks to widespread non-compliance. Yes, Brianna, do we have a question?
Yeah, so a question that kind of builds off of what you just answered. So in the case of an employer who just does not have any access to PHI, but is still a self-funded plan, do they still have to do all of these policies and procedures, or is the list of things to do narrowed a little bit?
Right, thank you. No, that is a great question, because self-funded plans, as we've talked about, are fully subject to the security rule. And while I would question whether any self-funded plan truly has no access to PHI, but hypothetically speaking, if a self-funded plan had no access to ePHI or PHI in general, they're still going to be subject to these rules, and so do still need to take these steps. But then when they're doing their risk analysis, they'll really just, we have no PHI, there's no ePHI anywhere. And so the appropriate security controls kind of write themselves in that instance, but they do still need to document all of that, that process. I also want to point out a lot of employers these days do have corporate security policies that can be leveraged for the purpose of meeting the HIPAA security rule. You don't have to reinvent the wheel with security policies when addressing HIPAA. A lot of those policies can be referenced in your HIPAA security policies. Proposed changes to the security rule. So at the beginning of this year, there was a notice of proposed rulemaking issued containing all of these proposed changes to the security rule. They had the comment period. Right now, where we are is in kind of a limbo, waiting to see if and when final rules will be published. And those final rules could be totally different from those proposed ones at the beginning of the year. So we don't know what they'll look like exactly, or when they'll be published with a newer administration. We don't know how they'll prioritize finalizing those rules. But when and if ever those did get published, the HIPAA covered entities would then have 240 days from that date, at least, to comply with those new rules. So a good time there. And then I told you to put kind of a pin in it regarding encryption and addressable implementation specifications, because one of the proposed changes is eliminating that designation between required and addressable implementation specifications, because the agencies found that a lot of covered entities ended up being non-compliant because they misinterpreted addressable items as optional. That's not the case. If encryption is going to be a reasonable security protocol, then it needs to happen. You can't just elect to not do it. There would also be more specificity and rigidity around some already existing requirements, one of which is required encryption for all EPHI. And I'll repeat now, these are proposed changes. These are not at all in effect or enforceable, but they're proposed. This is the direction they're going. This is what they're looking at. So that's important to be aware of. So regarding these proposed changes, obviously you'll want to be aware if final rules come out, but consider reviewing your current security policies and procedures in light of some of those proposed changes, because it does, even reading the preamble to those changes, it kind of informs us on how the agencies view these requirements, and how enforcement might play out even under the current rule, where though encryption is an addressable implementation specification in the early 2000s, at this point, I think it may be difficult to show that it would not be reasonable to encrypt your emails with EP that contain EPHI. All right, Dan is going to wrap us up with breaches. Thanks, Dan.
I see we only have a couple minutes left, so I will try and get through this section quickly. But starting with a breach. So what is a breach? It's defined as the acquisition, access, use, or disclosure of PHI in a manner not permitted under HIPAA, which compromises the security or privacy of that information. The regulations impose a presumption of a reportable breach unless which can be overcome only if it can be demonstrated through this four-part risk analysis that the information was not compromised. So the analysis considers first whether the PHI is sensitive, like financial or clinical information, like medical diagnosis, credit card information, the level of detail of the information, whether it could be used by an unauthorized individual in a manner adverse to the individual whose PHI we're concerned with, whether the unauthorized person also has an obligation to protect the PHI, whether the PHI was actually acquired or viewed. For example, if you found a laptop, could it be determined that the PHI was actually accessed? And then the extent to which the risk has been mitigated. For example, whether an unauthorized recipient has given assurances that maybe all copies of the PHI will be destroyed or will be returned without further access. So it really is a facts and circumstances determination. There are a few things that are not breaches, and that includes unintentional acquisition, access, or use by a employee if in good faith and within the scope of their authority, and there is no further use or disclosure. Inadvertent disclosures with a colleague who is authorized to access PHI, and there's been no further use or disclosure. And then finally, disclosure where there's a good faith belief that the unauthorized person was not reasonably able to retain the information.
And since you're pressed on time, Dan, I'll ask this one last quick question. Let's say someone mails PHI to the wrong address. So what is the procedure for correcting that sort of mistake?
Sure. So again, it's really going to come down to the specific facts. If, for example, the mailing was returned, undelivered, and unopened back to the health plan, then the breach exception may apply because the unauthorized recipient could not have reasonably retained the information. If, on the other hand, the information was not returned, or if the health plan was informed by the unauthorized recipient that they had received and opened the information, then the exception would not apply, and they would have to go through that four-step risk analysis to determine whether a notification must be issued. So if there is a breach, if a breach is discovered, then the covered entity is obligated to provide notice of the breach, and the breach is treated as discovered by the entity as of the first day that the breach is known or should have been known using reasonable due diligence. So it's not really enough to say that you didn't know there was a breach. Once the breach is known, then the affected individuals must be provided notice. And if the breach affects fewer than 500 individuals, which is going to be the most common situation, then they have to be notified within 60 days of the breach. And that breach needs to be submitted to HHS within 60 days of the end of the year. In more limited circumstances where the breach affects 500 or more individuals, the deadlines are a little bit different. HHS has to be notified 60 days after the discovery of the breach. And then probably most significant is that media outlets within the state or jurisdiction of the affected individuals have to be notified as well. So what does that specific notification look like? The entity has to notify each individual whose information was reasonably believed to have been accessed, acquired, or used as a result of the breach. That specific notification has to include a description of the circumstances related to the breach, the type of PHI that was involved, steps the individual should take to mitigate potential harm, information regarding what the covered entity is going to do themselves to protect against future breaches. The notice has to be provided either via first-class mail or email if the individual has agreed to electronic information. And in limited circumstances, other distribution methods may be used. Business associates, just wrapping up. If a business associate gives notice of a breach, the covered entity should go through their usual procedures in determining whether there is a breach. Ultimately, the covered entity is responsible providing a breach notification, but that obligation can be contractually passed to the business associate. The agencies do encourage parties to kind of determine who would be in the best position to provide a notice if necessary. And then lastly, even if there isn't a breach, just some other things to keep in mind. Requesting that the disclosed PHI is destroyed, provide notification to the individual, sanctions. So if an employee is violating HIPAA, it's possible that sanctions would be appropriate. And then keep in mind that any complaint regarding PHI needs to be reviewed, investigated, and responded to.
Bit over, so sorry
Yeah.
about that, Dan.
So yeah, we'll go ahead but thank you to Dan, Delaney, and Brianna for all of your time and insight today. Really appreciate it. We covered a lot of ground as it relates to HIPAA. So thanks very much. Also, big thanks to our audience. Really appreciate your attention. If you want to explore this topic further, as always, please reach out to that benefit advisor who invited you here. And just as a reminder, they'll also provide you with a link to the recording that'll be available early next week. And always thanks to our partners who make up AssurexGlobal for helping us sponsor today's event. That'll conclude our session today. Thanks again for your time, and we'll look forward to seeing you again next month. Thanks, everyone.